Well, good evening, everyone. We are on Verdict Watch Friday night in the case of State versus Richard Allen here in Delphi, Indiana. And I'm so excited that we have put together this roundtable discussion for you guys on everything Delphi. Very pleased to have Bob Mata from Defense Diaries and Lawyer Lee from Lawyer Lee. We're hoping to have Ali Mata from Defense Diaries join us later as well. So we are all streaming to our separate channels here, and it's a chance for us to all kind of get to know each other a little bit. So we're going to go ahead and start by just introducing a little bit about ourselves and how we got onto this case. So I'll go ahead and start. My name is Andrea Burkhart. I'm a practicing criminal defense attorney in Washington State. I practice primarily in appeals these days, but I did have an active trial practice for about 10 years, and I've been primarily a public defender for most of my career. I became interested in the Delphi case. Something I was aware of from very early on with the sealing of the probable cause affidavit. It caught my attention, but then just kind of fell off my radar. And it was really once that Frank's memorandum was filed that it really captured my attention once again. And then by the time the defense attorneys were removed from the case, I was pretty much hooked on the story. Problem is, I found it very difficult to access this case because transparency has been a real problem. And that's one of the issues that has been very important to me. So I knew when this case was going to go to trial, it was one I wanted to be here to be able to witness because the sources of information would be so unreliable. So that is my story. Let me go ahead and turn it to you, Bob.
So my name is Bob Mata. I have been a criminal defense attorney, I think going on 23 years now. Back in 2021, I decided to start a podcast. Asked my beautiful wife, who is also my law partner, hey, babe, I want to start this podcast. Can I leave the practice? Will you carry the entire load for us? And her being the absolute superhero she is, she agreed to do that. She is always going to be the hero of my story. So at any rate, back in 2022, when they had finally made the arrest in this case, I had been following it because proximity wise, I'm pretty close to Delphi. I'm an Illinois attorney. I've been practicing in Illinois. I'm licensed, but inactive in Pennsylvania because we were out there practicing for 4 years, but we moved. So we're basically Illinois attorneys, criminal defense attorneys. We've always done criminal defense trial work, which is, as you know, Andrea's gut wrenching, and it's. Mm-hmm. You know, it's an interesting profession, to say the least. So at any rate, I started the podcast, and then when I was aware of the case, but at the point that there hadn't been an arrest, I didn't really sink into that part of this case. It was kind of a weird vibe going on, a lot of accusation, speculation. That's not my thing. I'm a lawyer. I care about pleadings. I care about the process. That was what my interest was. So when the arrest was made in October of 2022, much like you, I'm wondering, gee, why did they seal this PCA? That's very unusual. And I started emailing the clerk every day. I'm like, hey, why is this sealed? When are they going to unseal it? So finally, when it gets unsealed, I look at it and I'm like, well, this shouldn't have been sealed. So at that point, I knew that there was something strange going on about this case. And then to couple it with the fact that Judge Diener, the original Diener who had signed the arrest warrant, it kind of like dipped out of the case immediately. I'm like, wow. Well, talking about bloodlust, I'm like, okay, there's like, I've got to cover this hard. So from that point forward, I ended up going to every hearing. And the more that I followed it because for the exact same reasons, I'm big on transparency. I mean, it's the reason that we have public trials in this country. We deserve and we have the right to know what our government is doing. And I was very concerned with it. And I only got more concerned as time went on. Obviously, when they had the whole ambush, when Brad Rosie and Andrew Baldwin were unceremoniously removed from the case, and she's calling them incompetent, and you know, all the things that happened. I was at every hearing and I just got more and more furious. And for me, it was never about saying Richard Allen was innocent or guilty. I had no idea. What it was about was the process, that we have due process in this country. Every defendant has the right to a fair trial. And I was trying to really explain to people what we as defense attorneys do, what our role in the system was. So that was kind of like, and I just followed it all the way through. I took a lot of heat for 2 years coming in. So when you finally got here in Delphi, I was like, oh, thank God, Andrea's here. Like there's somebody else at the table. I've been taking the meeting for 2 years. So I was so happy. I literally tweeted, I'm like, oh, thank God. Like Andrea's sitting at the table with me now because now she'll take that. So it's just a very divided, divisive, kind of social media world revolving around this case. And I think that all three of us, care about the same thing in terms of the system of justice. And we're Defense Diaries podcast. You can find us anywhere you get your podcasts. That's the same thing our YouTube channel is called. And I'm going to throw it to Lee.
All right. Well, I'm a Harvard law grad and I've been practicing for 30 years. There's almost nothing I haven't done across the 30 years. But for the last 10, I mostly represented whistleblowers who know about fraud against the government. It has a criminal component, but I'm not representing the person charged. I'm representing the whistleblower. But I started doing YouTube a couple of years ago and have been doing more and more of that. The thing that really got me about this case, the Franks memo was interesting. I immediately wanted to cover it. I mean, crazy, the things in there. But the level of work was really impressive. And I know how hard that is. And for defense lawyers for an indigent defendant not paying, it's really difficult to do that level of work. I mean, that was remarkable work that they had done. And then you could tell when they suddenly resigned and the judge announced that everything about that was wrong. I was like, people who write 137-page brief don't just resign. They don't do that. They are obviously people who are committed to this case. And so something's wrong. And I thought this needs to be covered. And just like Andrea mentioned, it was so hard getting any information. You couldn't see the hearings. And I thought somebody needs to report on this. This absolutely needs to be public because I talk about justice on the channel a lot. And it's one thing to talk about justice for the victims. We do that a lot in the true crime community. We talk about that, but that's if the wrong person gets committed, that's not justice. That's injustice. And if only one person gets convicted and there were 5 involved, that's still injustice. So it seemed to me so important that mattered so much for our system that people be here to bring eyes to it, like you both have said. So I fully agree with both of you and what you said.
Yep.
So one of the things that I think has captured a lot of people's attention in this case, and certainly mine, it's been one of the factors that was a little bit of a wild card I wasn't necessarily expecting, was the role of the judge and the sort of temperament and decision-making that we've seen, not even just from Judge Gohl. Bob, I want to refer back to your comment about the rapid recusal by Judge Diener. I want to turn to a safekeeping order, because this is something that I only came across considerably down the road. And it is one of the strangest pieces of writing I have ever seen a judge put his name on. Have either of you seen anything like that?
No. And the thing about that is that at that point in time, Richard Allen did not have counsel. So they went in on this hearing and they did this bizarre safekeeping hearing with no real threat being articulated to the court, meaning that, yes, there was a threat from somebody to Richard Allen. They were going to harm. It was all speculation. They're like, well, this was a high publicity case, so we were just worried that somebody was going to try to kill Richard Allen. And they end up going in. He's not even present. Not only does he not have an attorney, he wasn't present. So talk about the violation of due process there. That happens without Richard Allen having any say-so in the matter or having counsel representing him. At that point, I'm like, wow. Like, I just couldn't believe what was going on. And it was in June when Rosie and Baldwin filed their motion to vacate the safekeeping order. They had a full hearing. I was in attendance. That was the first time that Walla had testified in that hearing. And I was like, wow, man, there's something going on. And in that trial, in that hearing, that was the first time that I really got a sense of where Judge Gohl was in this matter, because she essentially called Rosie a liar. She said, you exaggerated the conditions of his confinement, which we now know were all true. Everything that he was saying in terms of this kind of prisoner of war like treatment that he was receiving was all gospel. And it was heartbreaking to me to think that we're living in a country where this is something that's acceptable in any form or fashion. To me, it was just something that we can't allow to stand. I mean, we can't. Otherwise, in a very different country, a country that none of us want to live in.
Lee, do you have any thoughts about the safekeeping order and the process of just how on earth? I mean, we've heard now through the trial, multiple people with decades of criminal justice experience say that this situation is unprecedented. I've certainly never seen anything like it in, any of the cases I've ever followed across the country. A man who is legally innocent, not convicted of any crime, never been convicted of any crime, and he's being held in solitary confinement in a maximum security prison for 13 months. What sort of, I mean, the role of the judge in all of this is part of what's particularly alarming to me, because we expect the judge to really be the safeguard against abuses of the process. And this seems to be an example where to me, there has just been a real dereliction of that responsibility in light of what's come out at trial. Do you think that's unfair of me?
Well, I mean, the way I look at it is that we saw, even in this trial right here, that they were unable to really articulate a reason that he was put in safekeeping. They asked the prison psychiatrist, what threats were there? Was there anything out there? He hadn't heard of none. There were no threats that he knew of. He didn't know why. And then the result of that was that this person fell through the cracks. There was an order that should have been followed, that 30 days was the maximum amount of time he could have been kept in solitary confinement. But because of this awkward safekeeping that nobody really had to find or figured out how it fit within the system, it meant that he was simply out of luck. He ended up stuck there. And the psychologist said, well, we talked about we should probably take him out. And they just didn't. They just felt like, he's safekeeping, so I guess he has to stay, and nobody was in charge.
And what's horrible too is that because by the time they had that hearing in June, he's already been there for, 6 months, 7 months at that point. We know now from trial, he's actively psychotic at this point in time. He's being involuntarily medicated at this point in time. And so for the judge to discount that and like Bob is saying, to turn this around and suggest that the defense lawyers are exaggerating or something like that, just strikes me as so deeply problematic, given that there is supposed to be an explicit policy about this in the Department of Corrections for people in his circumstances. And it's literally the job of the judge to be familiar with the law. And if there's ambiguity in the law, it's your job to interpret it. So that's just one of the deep concerns I have, is it seems to be it just seemed to be a lack of real concern or appreciation for the severity of what was really going on.
But it was known. It was stated in the pleadings more than once with the request, come on, move him out of there, move him out of there. And he didn't get moved. It didn't happen.
It was 3 times. So defense counsel brought it, and the 3rd time she finally moved him to Cass County, which at that point we were 3 months out from trial, so at that point the damage had been done, because frankly, when they moved him, and again, like when you start looking at kind of the full picture of this, the totality of the circumstances, he's moved under cover of darkness, like when the Baltimore Colts were moved out of Baltimore by Jim Irsay under cover of darkness, moving trucks at midnight. That was how Richard Allen was moved from Westville to Wabash, another prison, by the way, with no one knowing, absolutely no one knowing. Like I had messaged everybody that I had contacts with in the case. I'm like, are you guys aware of why they moved Richard Allen? Like to what? Like, was there an order put in place? I'm hitting the clerk up. I'm like, is there an order as to why he was moved? No one knows. To this day, when they brought it up at trial, they still don't know why or who moved him from Westville to Wabash, which is another correctional facility in the state of Indiana. So it's just the whole thing with this case has been like nothing I've ever seen. And Allison and I have tried some crazy cases. We've had judges that have been blowing hot in terms of not liking us. We're used to that as defense attorneys. This was a different level. Like I think I coined the phrase "something stinks in Delphi" probably about a year and a half ago. Like, and that became or Delphi unhinged, because either way, it was appropriate to what was going on with the process here. And just as kind of watchdogs from the defense attorney perspective, I felt that it was incumbent upon me and whoever was willing to come on board to say, hey, there's something wrong here. Because like I realized immediately that the lawyers in Indiana, no matter which side of the aisle they were on, were very much concerned about what was going on here, and then I was in attendance at the original action that they got through the writ of mandamus, which was filed by Kara Winnicky, and it was an amazing thing that it was done in very short order. And it's very telling when you have the Supreme Court of Indiana coming down with the decision, not weeks later, not days later, but the day that they had the hearing, they reinstated both of Richard Allen's attorneys. That spoke volumes to me. But they had also been asking to have Judge Gull removed for bias. So you have this battle going on between attorneys and judges, where I was just so deeply concerned as to whether or not they were going to be able to hold and conduct a trial the way that it should be conducted, where you have this just open animus between defense counsel and the judge going both ways, and it was a real concern for me. And I don't know that anything changed. I mean, we've made it through the trial. You could sense, at least I was very cognizant of the fact that she does not like Andrew Baldwin, Judge Gull. I think she tolerates Brad Rosie. There was no, as far as I know, there was no kind of delineation of who was lead counsel, but you can tell Gull always addressed Brad Rosie as lead counsel. She would ask Mr. Rosie, "Are you ready?" every morning when we were sitting in there. So, where this is a situation, and just in case those of you don't understand, in this particular county in Indiana, they do not have a traditional public defender's office. So you have private counsel that sign up on the public defender's list, to where they're saying, hey, look, in smaller counties that don't have like an actual like physical public defender's office within that county or that courthouse, that lawyers around the area will be, they'll be appointed. And that's what happened with Rosie and Baldwin. They both had their own private practices. They had never tried a case together. So they were kind of stuck together. And I think that there was probably some back and forth in terms of talking about who they were going to appoint, because obviously they wanted to appoint some people with some experience, a lot of trial work under their belts. And both of these guys fit that bill. I mean, both of these guys they're 50 years of trial work between the two of them, so they were definitely a couple of guys that had gone around the ring quite a few times and knew what they were doing in that courtroom. And as a defense attorney, I was personally offended with the things that she was saying, besmirching the character and the fitness of these two lawyers who had done nothing other than file a voluminous motion that was unlike anything that I'd ever read. It's like Lee was saying, it's like when I read that Frank's motion, I was picking the pieces of my skull off the ground. I'm like, anything like this, and I know, Andrea, you had followed, the Karen Reed case. And the one thing I kind of said that there was a common denominator with both those cases that we do not see typically in any kind of cases of this magnitude. And in both those cases, the defenses had laid their entire theory of defense out for the public by way of a pleading, which is well within their rights to do. But it's typically not something that we do, because we don't necessarily, that's the one ace we have up our sleeve as defense attorneys. We do not have to disclose our theory of defense. Obviously, there's reciprocal discovery, but we don't have to tell them what our theory is. So when we did that in this case, and they did it in Reed, you saw this split in terms of the public that now had not just one narrative, which we've always been used to. We've always been accustomed to hearing the state's theory through their probable cause affidavit, or, you know, if they go in on an information, like we get the state's concept of what they think happened. You know, in this case, it was different. We had both sides out there laying it out on the table, and it became evident to me, and Gull would never admit it, she hated the defense. She hated that third party culprit Odin thing. It bugged her to know.
She made that clear.
She did.
Yeah. Made that very clear.
She didn't. She just said that there was no nexus. She never admitted. Right.
I mean, I think that it was clear through sitting there. I mean, she ruled against the defense pretty much every motion until we got to the prison psychiatrist, and she ruled with Rosie like 25 times in a row.
Because he was having such a hard time testifying. Well, you know, one of the things that really bothered me about the whole antipathy towards the defense team is it became very concerning to me that this was a distraction, that this is, I mean, I don't want to say deliberate, but just the effect of it is certainly going to be to take their attention away from the work that they need to do to prepare the case for trial and to respect their client. If he's got, you know, he wants to assert his right to a speedy trial, then you need to do your absolute best to be able to carry that out. But at the same time, they're fighting this two-front war because they've got the judge coming after them, you know, through this disqualification process that they have to fight. And then they have, even after the writ came down, they have Mr. McLeland, you know, independently coming after them now with a contempt proceeding. And so it just became a very dangerous process, I thought, as someone who obviously is in the defense arena. I am, like you, Bob, rather accustomed to judges not always being all that receptive to what I have to say, or to, you know, my theories of the case and so forth. But you expect there to be just a baseline of respect and recognition that you're an officer of the court. You have a duty to do your job with integrity, and the potential effect that had on this case and on the fairness of the process as well is, I think, something that maybe hasn't fully been appreciated.
I felt like when they wrote that brief, and you could find fault here or there with it, but it was an amazing amount of work, and the thoughtfulness it showed in wanting to present the absolute best possible case for their client. To me, that was really commendable, because our system is dependent on the idea that we bring people from both sides. And when they come from competing sides, that's when the person making the decision makes the very best decision. So you're depending on a prosecutor who goes hard from this side and a defense lawyer who goes hard from this side. And that was an example of somebody doing exactly what they're supposed to do within the system. And I thought they should be commended for that. I don't understand. Why would you want the person out who's doing exactly what is best suited to make the system work?
Yeah.
And I think it's so unfortunate for this process too, because I mean, like Bob has pointed out, that the case has become very polarized and it's very opaque. It's very difficult to get information. We've all had the advantage of being able to sit there in the courtroom and see what the evidence is as it's played out, but that hasn't prevented these very strong opinions from forming. And so we're at this point where really, no matter what the verdict is, you know, if we get a verdict, there's going to be, you know, some people who think that it isn't right or it isn't fair. And I mean, obviously there's a whole conversation about transparency that we can have about that too. But I think it's just very unfortunate that this third party suspect defense didn't get the chance to get vetted in court, because I think that would have potentially resolved a lot of doubts or a lot of questions that people might have about how strong really is the case against Richard Allen. Is there a legitimate reason to think that it might be other people who committed this crime? And so it's just created a little bit of a vacuum for that doubt to remain, because we didn't have the chance to get the evidence brought out and have it tested through, like you're saying, the crucible of the adversarial system.
And my opinion is that knowing what's gone on kind of publicly with this, and as we've gone through the process of this trial, I've decided, you know what?
this is where I'm at. My opinion on this case from the moment that PCA had dropped, that it leaned innocent. And that was always my position. I'm like, mere presence is not enough. Like, all of us trial attorneys know that. You being somewhere is not enough to get you convicted of a crime. So I'm looking at that PCA and I see mere presence at the bridge, which he volunteered the information, and I'm seeing an unspent casing that some forensic analyst basically says, look, subjectively, I think it's a match. That's it. And that's what we had. So I'm like, look, that is not enough. They need more. They better have more when they get to trial. I had always been in the position. I think they made the rest, hoping that when they got to all of his devices, that they were going to find that link. They were going to find the link to either Kagan Klein or somebody, like that. They were going to find the link, because they always, despite what they're testifying to in court, and I'm talking about law enforcement, the fact of the matter is they always thought that this was multiple actors. Always.
And they said that, several said that up until the time of Richard Allen's arrest, they believed it was more than one person. And frankly, at his arrest, they believed it was more than one person.
No, we're going to leave the tip line open. Right, exactly.
At the press conference, they said, hey, remember, this is still an open investigation. And if there are other people you know information about, bring it to us.
But so here, this is what I like. So now that we've had the trial, and knowing what the kind of the general consensus, the people that believe he's guilty had believed he was guilty on those two facts that we're talking about, the mere presence at the bridge and the round, and which is essentially what their case is. Aside from now these, depending on how you look at these confessions, I look at them as coerced through a coercive actions by state actors, wherein they put this guy in a position where he lost his mind, quite literally. So where I'm at with it now is, if this jury comes back having only heard what their case is, without the smoke and mirrors of the defense Odinism thing and the third part, and they come back and acquit this guy, I feel validated. Okay, here was your case. So you kneecapped the defense. You kept out every third party culprit that was legitimate from this case, and now you brought your case for what it was, and you got a not guilty, probably because of reasonable doubt. Like, I don't know that they'll reach the acquittal if they get there from the fact that they think he's factually innocent. They'll get there because they said you didn't prove it beyond a reasonable doubt. And to me, that validates the fact that this was a case that should never have been brought because it wasn't strong enough. You know what I'm saying? Like, when, and I was there for the hearing for the third party culprit thing. And that was Andy Baldwin's baby. So it was like you had this strange kind of split between the team where, again, they're not in the same practice together. They're trying this case together, and you had Baldwin that was all about the third party culprit stuff. And you had Brad Rosie, who was all about, I'm going to attack the gun. I'm going to attack the confessions. That's what I'm going to focus on. Andy, you handle that. And we saw that in closing arguments. You saw kind of the things that maybe we would have liked to have heard a little bit more about in terms of attacking the crime scene, and, some of the strange things that were involved with that crime scene that we didn't really get much of in the closing, because Brad focused much more on the confessions and the gun. And that's part and parcel, because that was not his baby throughout the course of preparing this defense for his client. So like my bottom line is, if they get an acquittal, I think that it'll be very eye-opening to all those that believed he was guilty, because those 12 people, all they heard was the state's case. The defense didn't get to put in any kind of real defense other than trying to create reasonable doubt. So to me, that'll be very vindicating in terms of, I always thought that it was a very weak case. I didn't think it was a case that was worth bringing in terms of the evidence that they had at the time of arrest.
Yeah, and I think I share your opinion, Bob, about this not being a particularly strong case. And at the same time, here we are. We've been a day and a half into jury deliberations. And while, of course, it's pointless to try to read the tea leaves where a jury is concerned, because juries can be unpredictable, I do think that it's doing them in this process a disservice to discount the possibility that there are people on the jury that think Richard Allen is guilty, that think that he committed the crime. And so I'm curious about your thoughts as to what do you think the strongest point is that the prosecution raised, the best point that they have, that a juror that's back there in the deliberations thinking that Richard Allen is guilty. Why? What is it that juror you think is hung up on?
I think it's the confessions. I think
Mhm.
because while some of them had some words in it that made it less serious, like he would say, I did it. Well, I think I did. Okay,
Mhm.
that makes it really confusing. And I
Mhm.
understand that the defense put in some good expert witness testimony about the creation of false memories and false testimony. But when I heard that confession to his mother, that had a
Mhm.
completely different level. It sounded very coherent. It sounded very lucid. He responded each time to her. He fought with her when she said, no, you didn't. Yes, I did. No, you
Mhm.
didn't. He sounded calm. He sounded rational. And he repeatedly said, I did do it. And I want you to understand that I did it. And
Mhm.
I thought that was a serious problem for the defense when I heard that. As
Mhm.
soon as I heard that confession, I thought that's going to be a significant hurdle for the jury to get over.
See,
Mhm.
in my feeling on the kind of in the totality of the circumstances when they were able to get that critical evidence in terms of the conditions of his confinement, I think it became clear that this didn't have to be a situation where you had odinistic guards who had patches who were that was a thing. That was an actual thing. Like
Yeah.
we had affidavits from the guards who admitted that they were wearing, like those people were guarding Richard Allen. So, but
Mhm.
aside from that, because you're never going to get a guard from a correctional place that's going to say, yeah, we were threatening his wife and his daughter. They're not going to admit that. To me, what it meant was that it was much easier after 7 months, once he's in a psychotic state, for them to say, hey, you want this to go away. You want to see your wife finally after 7 months. Just say you did it, man. Like, just
Mhm.
admit it. And they all had that feeling to me. Like none of
Mhm.
them were like, because if I've got my mind right and my wife knows me and I've been married to my beautiful, brilliant wife for a long time, and if I've committed a crime like this and I'm coming clean, it's not going to be, I did it. Yes, I did. No, you didn't, honey. Your mind's not working. They're messing with your mind. I did it. I mean, I think I did. I don't know. I did it. It would be, babe, like, listen to me. Like, I know you don't want to hear this. Like, I
Mhm.
know you, like, I don't even know how to, I'm saying these words to you, but I'm telling you, I committed this crime. I don't know what, you know what I mean? Like, there is
Mhm.
no conversation like that, Lee. There is nothing that's even close to like a genuine confession from a husband to a wife who we know unequivocally Kathy is his rock.
Mhm.
She is who he relies on to hold him up in life. Like he needs her, like
Mhm.
beyond, So for me, it's, and I've said it before, that this casing, this unspent round, even though us as attorneys realize that, look, there is absolutely no validity in the law in terms of that being the type of evidence that should be the crux of a state's case, not in this country, not an unspent casing, not that thing. I mean, even just regular tool marking stuff is like under just huge fire all over courtrooms in this country. But the problem is, and I've said it all the time on my channel, is that for jurors that are lay people, if you get a cop in there to say that it's a match or
Mhm.
mission agreement, it's very, very powerful evidence. So powerful
Mhm.
that it scares the hell out of me, because you can have a guy who's going to like get on the stand for the defense and say, there's not sufficient agreement, and this is why she didn't show her work. But you're still getting questions when he's on the stand. Hey, Mr. Defense Expert, did you know that had been validated by somebody else? So
Mhm.
the power of that evidence. It's like, that bullet scares me in terms of just
Mhm.
being a selling point, because it's really their only link from Allen to that crime scene. I mean, without that, you've got these confessions. Because, like, look at the case, just remove the confessions, and what do you guys think? Pretend the confessions don't exist, and look at
Mhm.
the fact of that case. Where are you at with that? You know what I mean?
Yeah. Yeah. Well, and I mean, as far as the bullet's concerned, especially as this got fleshed out at the trial, I have really grave concerns about this even meeting the threshold for admissibility in court. The fact that it turns out this is a comparison of an unspent round to a fired fired casing. There's been no apparent validation or even like real study of whether this is a type of testing that's appropriate, that's going to be reliable, that it's something that would be accepted in the forensic community generally. That to me is a real problem. So at the very least, I think that there should have been more of a threshold evaluation of the legitimacy of that process, and put the burden on the state to substantiate that what they're offering here is in fact reliable science. Big hot button for me, the junk science in the courts. It's just been a problem for decades. It continues to be a problem. So I'm definitely with you on that as far as the bullet goes. For me, I think the hang up that I would have if I was on the jury is the van. It was this last second wild card, and there's plenty of weaknesses in kind of how that information came about and how it came to their attention, and then how long they sat on it before they did any follow-up. Basically waited until the eve of trial when it's pretty clear, okay, the defense is calling your bluff and we are in fact going to have a trial here, and you need to try to put together some kind of smoking gun. And that became, within 2 months of trial, a very critical component of the prosecution's argument that this is information that only the killer would know. Because that is very compelling. If we can discount the confessions because of the circumstances, we still have to focus a little bit on the content. And that was always the risk. I think of these confessions, is that if there is anything in there that is, we can't attribute it to the discovery, or we can't attribute it to information that he'd gotten from another source, or just, some kind of detail that there's not really a good explanation for why he would know it, that is a really bad piece of evidence and piece of information against Richard Allen. So the van, they really had two pathways to attack it. They could attack it on the pathway of it simply didn't happen. Brad Weber is lying about that van being present there. But they also really needed to attack it on the ground of, why did Richard Allen say this anyway? Or did he even say this anyway? Right. Like, just more of a focus on, is this something that he was fed? Is this something that could have been in the discovery? We've kind of seen out here through, or at least I have through some of the social media conversations, that people have found a lot of conversations going on in the forums and stuff like that about white vans, over the course of this case. And we know, of course, Dr. Walla had that rather bizarre, as Mr. Rosie put it, true crime fascination and just the almost Machiavellian kind of role in this case. And so there was just a lot there that I felt maybe didn't get sufficiently addressed to be able to undermine the strength of that particular piece of evidence. Brad Weber in particular, I feel like the defense was put in a really bad position, because when he was on the stand the first time, it was a train wreck. I mean, it was an absolute disaster. He has this rage outburst. It's just very bizarre looking. And it became a whole issue because later on, when the defense is trying to get permission for the FBI agent to come in and testify about what Brad Weber had told him, and to do that remotely, it turns into this whole dispute about whether they had properly laid the foundation to impeach him. And I thought that was really unfair, because Mr. Baldwin did an absolutely textbook job of confronting Mr. Weber with his prior inconsistent statement, giving him an opportunity to explain or deny it. He in fact denied it. That opens the door for him to be impeached with it. But Judge Gohl, apparently didn't see it that way, wasn't going to allow the FBI agent to come in and testify. And so it really put the pressure on the defense to have to go in and put Brad Weber back on the stand. And then when he did go back on the stand the second time, I thought he did much better.
Almost like he was prepared.
almost like he was prepared and was warned, maybe, dial it back on the attitude a little bit. But he didn't come across nearly as combative or even as resistant. I thought, frankly, he came across as seeming much more sincere the second time around. And so it has the unfortunate effect of potentially undoing, what they'd already accomplished when he was on the stand the first time. Okay, this guy looks really questionable, and I don't know if I'm going to really buy his story. But now we get him the second time around, and he does. He seems much more forthcoming. He's not resisting their questions. He's giving them the information that he wants, but he's also sticking to his story. And I think that really hurt.
I don't disagree. And, I thought that the easier route, which in terms of Walla, I have to be honest, I was shocked that the defense didn't call her. You know how awkward it is to direct examine a potentially unfriendly witness to your case, right? I mean, it's much harder to do in terms of extracting information and be able to control the examination of that client when you really want to be crossing them. But they should have called her back, because I thought that when Dr. Walcott brought out that concept of like, look, when I'm reading her notes and she had this entire like kind of block narrative in story form with a beginning, a middle, and an end, it was completely unorthodox to what I'm used to seeing. Now, when you couple that with the fact that we know that Monica Walla joined seven different Facebook groups from all varieties, but primarily those that seem to believe Richard Allen was guilty, and she joined them on the day that she found out that she was going to have Richard Allen as his patient. Now, like Sleuthy Goosey, who is a friend to you and I, she's the one who dug that up for me. And then she joined our group, Defense Diaries group, on the day of the safekeeping hearing after she testified. My point being is is that a tough argument to make about somebody who's a licensed psychologist that is, like that she potentially could have added things? I mean, I have a hard time believing that Richard Allen in that state, which we know what he was at that point, used the term, I was lying in wait. That smells like bullshit to me. I'm sorry, but it does. There is no delineation of it's not a white van, it's a van. Like there's just things about it where I think it would have been very easy for her to create this kind of narrative if she really felt like he might be guilty. You know what I'm saying? And even if it's subconsciously, if it came to a thing where she's like, is he feigning? And she's got to make that gut call. If she's reached the conclusion in her mind that he's guilty, which way do you think she's going to lean on the answer to that question?
I had Jumpsuit Pablo on my channel and asked him about some of the questions that I had about his behavior in prison, the eating feces, the stuff that he was doing, and also the long-term in solitary. And what he said is that a lot of that is textbook what prisoners do when they want to get out of solitary, that it's manipulative, the whole eating feces, the stuffing paper down your toilet, and that he figured somebody sitting near him was guiding him and suggesting this. So I was really surprised by that, because that was not how I took it. But that made me think that maybe that's what Dr. Walla was thinking. Maybe she's in that environment, which I'm not used to and which didn't seem to make sense to me. But maybe inside that environment, her thought was, maybe I've seen other people do this. Maybe these sorts of behaviors are manipulative. I think in his case, it didn't really appear to be that way to me. When you saw his behavior in the one clip we in the audience were shown, it seemed pretty sincere to me. But I wondered if that was why Dr. Walla felt that way. I guess you're right that there could be sort of a Machiavellian plan on Dr. Walla's part to create a narrative where he admits and confesses to the crime and she kind of creates the facts around it. But that's a long way from, I'm interested in true crime and I stayed interested in that even after I treated this patient. while I think it was wrong of her to do that, I just don't know that the jury is going to go so far as to attribute that sort of broad scheme to her where she would even create the confession. I mean, I understand the argument and why it needed to be made. All of the arguments about Dr. Walla did need to be made. I just don't know if the jury will go that far.
We have a new addition here. Sorry to get you by surprise here, Allie, but
Yeah, she told me specifically not to pull her on until she was ready.
It's all right. I'm ready.
so sorry.
It's fine. The lighting, I don't need lighting. I don't, it's all good.
So let me just introduce, because I had agreed to do Court TV tonight. So my much smarter, much more attractive, better half, who's also a brilliant legal mind, along with these two other brilliant legal minds in here, I'm gonna tag out. She's gonna tag in, and I think you guys are gonna probably enjoy her company as well. So I adore all three of you. Frankly, I'm super sad to leave this conversation because I've been dying to have it.
Hi, Dave.
Who knows if we're still on jury watch tomorrow night, maybe we re-up it. Who knows? You guys are amazing. I love this. Have fun and talk it out. Let's figure this thing out.
Thanks so much for joining us, Bob. That was a great idea that you had. I'm glad we finally got to make it happen.
Me too. All right. Have fun.
All right. Bye-bye.
Bye.
So welcome, Allie. We are just, kind of having a little free-form conversation here about all things Delphi. We do actually have a couple questions that have come up in some of the chats. And so I'm definitely interested in your guys' take on this one. Monday morning quarterback question. Based on what you know, would the defense have been better off keeping the speedy trial demand and a 3-week trial restraint or whatever it was? They essentially tried to push this to trial, within the speedy trial framework. It is Mr. Allen's right to invoke if he wants to do that, but the attorneys can have a pretty fair amount of influence over the client and their decision in that regard. So I'm interested in what your guys' take on that was. Do you think the defense should have maybe taken a little bit more time on this, or was it more important to really push it forward?
I was all for them taking as much time as necessary. When you've got someone whose literal life is at stake, and basically he's got nothing but time, even though, I think what their fear was, they were emotionally driven by how deteriorating, it was for him and how much he had emotionally, mentally deteriorated. And I think that may have been a driving factor. I don't know, but I just remember thinking, at least back then, I was like, it doesn't seem like they're ready because they're filing motions saying, we don't have this, we don't have this. And I'm thinking, has anyone analyzed the cell data yet? Who analyzed the cell phone data? So to me, I think they needed, at least as much time as they got. Who knows if they could have used more time or not, but if the question is like, would they have caught them off guard? Because now we know, they just found this van thing, like this week. Who knows? But then there's stuff that they wouldn't have had on the flip side of that. Clearly, they wouldn't have had the cell phone stuff and, some other things. So
there's always stuff you find right before trial. Always. Yeah. And the fact that you're steeping yourself in it, preparing yourself for the trial, you just notice things that you didn't notice before. So I think that still would have happened.
I agree. One time, as an anecdotal, just as an example, Bob and I were on trial, and it was a drug case, and our client was supposed to have been the lookout. He was kind of there. And, you've got some clients who talk to you a lot and tell you everything. And I think this client talked a lot to maybe some of our assistants. And I don't know if everything was ever communicated to me the way I understood it the Sunday before Monday morning trial. And I'm rewatching, the police had the surveillance cam set up, and I see my client come outside. And I did remember him saying he was trying to get picked up. He was trying to get his wife to come and pick him up. You see him outside. He's looking around. he makes eye contact with and I missed it the first time around. And it also wasn't all that important, I think. But so in any event, I mean, overall, the surveillance, you see him stare and you actually hear the cops say to each other, he's looking right at us. So I call the guy back. I'm like, I scream for Bob to come up. I'm like, you have got to see this. And then I was like, we called the client. We're like, what was going on? Had you noticed the cops? He was like, yeah, they were in the car at the thing, like went through this whole thing. And that's why I was trying to have my wife pick me up. I tried to get out of there. I didn't say anything. So like that, we ended up with a not guilty. And it was definitely all because we were able to establish he knew the cops were there. He didn't tell anybody. He didn't say to these guys, stop what you're doing. He just tried to get out of there because there was some other evidence that he kind of got picked up last minute and not even told why he was sort of going over and like roped into the whole thing. But again, long story to say, Lee, obviously you're absolutely right, because like you said, you're steeping yourself in everything before trial. You're not thinking about anything else. You're going over every little detail. And I'm very much like that usually. Like when it first comes in, I make sure I really, really see everything. Didn't see that.
Yeah, there is always the benefit of hindsight anytime you're in trial, and then that gets exacerbated too by the fact that you never know what's going to be significant to the jury. I mean, oftentimes in Washington we are allowed to talk to the jurors after the case if they want to, and so it's a common practice to just have a little conversation about what worked, what didn't, what was very influential for their decision making. And oftentimes it just has absolutely nothing to do with anything that I thought was going to be the important issues going in. I did have a little bit of concern about this one, though, just in the sense that I mean, maybe this is me and my, a little bit type A, just want to exhaust everything. I don't like being caught off guard in trial. There was so much like late dripping in of information and discovery. And apparently, I mean, the suggestion was, even as the case was going on, that there continued to be things that the state had not provided to the defense. But there were two things in particular. And one of the reasons I pulled this question up was because we were just talking about Dr. Walla and her history with social media. And I don't know to what extent they had an opportunity to really be able to thoroughly investigate that and exhaust that, to pursue, the subpoenas to the social media, because I know she deleted stuff. So you can't just go online and get copies of it anymore. Makes it a much more complicated process to go back and try to recreate what her actual activity in these types of forums was, because I think that if it's there, had the potential to tell a very, very important part of that story as far as her relationship with Richard Allen and the extent to which it may have been really inappropriate. And then another piece of that too, with the white van and the way the story kind of came out, to be able to try to follow up, with subpoenas to Brad Weber's, bank accounts, there's probably not security, video at this point in time, but just any type of record, service records on the ATMs, records of the payment when they get the fee that he was talking about, and then they split it with the owner. Like, is that something that there would be a record of payment of, to just be able to explore that, to see if we could nail down potentially a little bit better exactly what the circumstances were surrounding the ATMs that morning. But at the end of the day, I mean, it's kind of like art, you're never really done. You just have to stop at some point,
Right.
and just be ready to go. So I definitely don't want to fault them. And at the end of the day, I think the concern about Richard Allen's well-being was very much a legitimate concern, and really, seems to continue to be. He does seem to be doing better, certainly, than he was back at the time of the safekeeping hearing. But in light of everything we've learned of how he was treated, the fact that he's kind of a fragile egg, as Dr. Westcott put it, it does give me concerns that his status is tenuous, and that there's potentially always going to be a risk that he could just deteriorate again.
Well, and I wanted to ask you, and I'm sorry, Lee, you should go first.
Okay, thank you. The piece of evidence that I was just really appalled by that they had not dealt with is the hair in Abby's hand. That's inexcusable to me. There was a hair in the victim's hand, often a place where if there's any kind of fight, somebody might grab hair. So you look for that. I mean, it's a known place that law enforcement is going to look, and it had a root. It was not untestable. It wasn't something where they had to send it to the FBI for experimental testing. This is right there, easy pickings. And they did nothing until immediately before trial. It ended up not being an issue that either side wanted to pursue. But it really was pretty telling about the process of the investigation, because that absolutely should have happened. That should have been done. Another thing that I thought came out pretty well from the defense was the hairs that could have been tested by the FBI using the new system. It wasn't perfect. They didn't have all the kinks worked out yet, but it could have been tested. But they elected not to, on the theory that at some point in time in the future, there might be a better way to test that would not be destructive. And the question from, I think it was Rosie, was like, or maybe it was Baldwin, but he's on trial now. He's on trial for murder now. We don't want to wait till then. The only reason to wait is if you believe there are other perpetrators, and you think at some point there could be a way that you can pull out DNA from these other hairs that didn't have roots, and you can nail somebody else, despite the fact that people came into this trial and said, we now believe there's only one.
Right. And that's so along those same lines. And Andrea, to your point about Weber and Walla and social media, I would agree they had zero time to do that, because, or maybe it wasn't, maybe they didn't think it was as important. Although I see your point. You want to know how deep was she, you know, to point out any more bias. But when you tie it to the van, and there definitely was social media from 5 years ago. I looked at Reddit, because it's sort of easy to search Reddit that many years back and tie it to, you know, Delphi van, you know. Well, what about that van that was on Route 625 at 3:30 is what the time that it said back then. And so I think they could have also, if they had known, they could have, because look, and maybe you guys know the answer to this. How long has the state been saying he confessed to things only the killer knew, as compared to when they interviewed Weber with about the van? Do you guys do you remember when was that? I thought that was like real close.
I don't know when they first did it. One thing I did notice, they repeatedly talked about things, the facts, plural, and in the end, it was only fact.
And I think that they were saying that before they had the white van tied together. But to circle this all back, he said on the stand, I used my text messages to figure out what I was doing in the van. Continuance, order this man to give us his cell phone, have the police, like, we need to see this. We need to depose him right now. There were so many times that I'm listening to Bob's Live and I'm screaming, continuance, like the box cutter thing, he didn't say it in this, he didn't say it in that. And now he says it. Like, I needed them to really tie together for the jury what was because the first time they heard him say it was at trial, and they know he didn't say it as deposition. I don't remember the time. I think Bob told me the dep would have been after he confessed. I don't know, maybe it was before, but like, don't you think they would have very well, especially, I know gold can be difficult. He said the words, I used my text messages to figure this out. That would have opened the door and given them an avenue to his text messages. Yeah.
No, I absolutely agree. And the reason why this came up is just because we're talking about, like, we got here from the conversation of what if the jury is hung up on something that you got jurors in there that are convinced that he's guilty. What's the piece of evidence that they're hung up on? My view of that was this van, and just my sense that because the van has the potential to be such a powerful piece of the case, it was really important for the defense to really be able to attack that, to diffuse that, and to emphasize either it didn't happen or this is part of the setup by the state, which I think was a viable argument, but just really didn't get pushed. The defense didn't lean nearly as hard on what I saw as being very clear instances of deception by some of these law enforcement witnesses, particularly Steve Mullen, and to really incorporate that into their theory of the case and what they're pitching to the jury in terms of their perspective, because Mullen is a critical part of that. But he got caught out several times making claims that once we got to see, for example, the interrogation video, it doesn't play out. Seeing them play the fast and loose games with the search for the forward focus, all of these types of things I thought was potentially ammunition for the defense to be able to go at the van. But just because that did become such an important part of the state's case, it was really important to attack that. And I'm concerned that maybe they just didn't do enough in the eyes of some of the jurors.
I did hear them try to say, they asked a question. They started with the cargo van, but then I heard them start to read, and I recognized that language because it was like, I think they started to say, what about a van near, and in my mind that was going near Park 625. I mean, I know though that stuff existed out there. And that she said, hearsay, but if they could have asked for a continuance on the fact they just told us this, it's their one thing the killer only knew. We need the opportunity to establish it was widely known in the public. And they could have used someone like, I know you've been following Kohlberger. Is that right? They could have used like the jury consultants who could have run through all the social media. I'm sure that they have and then they could have put it together about how many people would have seen it, how long it's been out there. And because one of the jurors' questions was, but why were people talking about a van before he said it? But they didn't really, unless I missed something, you guys were there. My understanding is he kind of asked these questions, but there really was no evidence about it.
That is true.
Yeah, it came out from Andy Baldwin through his questioning, but of course that's not really substantive, and so there wasn't ever anything like from a witness saying this existed in the discovery, this existed in the social media. That was a potential pathway for this van to enter the conversation in the first place, and I think that's a problem.
I thought that's why they had designated the legal intern, Matt Baker. Initially, I figured they were going to use him to do two things, maybe talk about specifically what information was available to Richard Allen in the discovery, which they never talked about, and in this case, with the new issue about the van. But they didn't use him for that. They used him for the video.
I think it's possible that I remember that they came back and the judge said, I got this report and it's not getting in one day. And I was thinking that was Max's report, because the way the rule in Indiana seems, if he spent hours searching on the internet and he printed the page and could say, that's the page I printed, I pulled it off of Reddit, they were talking about this is what it looked like, and they were talking about the white van 5 years ago, 7 years ago, blah, blah, blah. I was thinking it was that. And again, it's not for the truth of the matter asserted. It's for the mere fact. And I did some research. There is, it's obviously not an issue that comes up all the time, but can be an explainable hearsay exception that and a nominal authentication. You don't need as much as Google to say, what's Facebook going to say? You just need someone. Most of it says who viewed it at the time, but I still feel like, because it was just to show it was available to the public, at a certain time. But I think if they had that extra time, if they had known ahead of time, then they absolutely could have done that, to either with like a company similar to the kind that you use. And maybe you can explain a little more for people who don't know what I'm talking about, like how that would have been helpful to use the type of like you use in the jury consultants to see what press is out there and where it is. They put a whole statistical package together.
Yeah, and I think that's where the defense has been so hamstrung by just the lack of resources. There's so much that they could have done with this case, but they weren't getting the money from the court, and they had to, crowdfund for things that frankly should have been like not even as a question should have been afforded to them. The ballistics expert just being a prime example. The state's gonna present this evidence, and the court's not going to give you any avenue to even be able to evaluate the merit of that claim. We defense attorneys, we're used to dealing with this type of evidence, but we're not experts in it. We need experts to help us look at the record, look at the testing, the people who understand what the standards are, apply them on a deep level, to be able to even let us know if there are really red flags here. And I think the real strong example of that would be with DNA. I mean, there's just no way that I would be able to look at a DNA analyst's file and look at their electropherograms and things like that and have any idea whether there's any problem here, whether this is valid testing. So you absolutely have to have experts to be able to guide you along that. And so the defense was really just hamstrung so much, even just in being able to defend against the types of resources that the state had to bring to bear, let alone then to be able to develop their own independent theories and their own independent testing and things like that may have potentially helped their case.
And I think people have difficulty understanding what a difference there is in resources between the prosecution and the defense, because the prosecution has all these people who are just a stable of experts, because the police have a DNA expert. The police have people who do fingerprints. They have people who do each and every one of the different things. And so for the defense, though, they've got to hire somebody, and they hired excellent experts, but they cut corners because of, I think it's funding. It has to be funding. But for example, they didn't do reports, and it ended up hurting them. You could tell from the juror questions. The jurors were like, well, why didn't your ballistics guy do a report? Why didn't he look at this bullet and compare it? And I'm sure if they had had unlimited resources, they would have asked him to do that. And then the jury would have at least had a clear-cut explanation for what the difference was. And if he ended up agreeing with her because he said he might, well, then they would know that. But if he differed from her, then they would have known that as well.
And one of the things I hated about that line of questioning too is because when it came to the prosecution and the decisions that they made going forward with the case, that's off limits. We saw that come up a couple times where I think it was Mr. Mullen who was being cross-examined about the choice to, for example, cherry pick that forward focus data and what goes into the jury and stuff like that. And objections to that are being sustained because it's not his job. He doesn't get to decide what the prosecution chooses to put on. But then, when the shoe is on the other foot and we're talking about the decisions, the strategic decisions of the defense attorneys, that seems to be fair game. It's unfortunate. I mean, it's coming from the jury. I know they want to know the answer. And so I guess in some ways it just means you have to answer that regardless, because even if you go and you have your sidebar and the judge agrees this is an improper question, we're not going to submit it. Well, then it's still in the juror's mind and they just don't have any explanation for that at all. But it is just very
because they
unfortunate they didn't have an avenue to be able to explain that.
They did that with the sorry, I was cutting you off. They did that with the question about whatever question it was the state asked at the end that then she let the jury ask. And I thought if it was inadmissible or outside the scope or whatever it was, evidentiary couldn't get asked by the lawyers, why would she let I didn't understand that. Why'd she let
that really bothered me too.
Yeah.
The lawyer wasn't allowed to ask it, and yet the juror could. I mean, I was like, no, it's not good for either one to ask. There was a reason for that.
Yeah. So this is definitely a question that we get a lot. Oops, it was just on the screen. I don't know if that can be put back up. But the question was, how can an official inquiry into this situation be launched? I have ranted on my channel more than once that if these circumstances, particularly the circumstances at Westville, if these don't cause the FBI to be taking a close look at this situation, then I'm not sure why we have an FBI. But this is just a circumstance that, again, I think we as lawyers have a little bit of a perspective on how difficult it is to question the questioners, to investigate the investigators. I have really, racked my brain about this. And part of the problem is because the FBI has such limited jurisdiction in their own right to go and investigate crimes. They're pretty much there at the discretion of the agency that does have jurisdiction over the crime. And so if the FBI in this case had really any independent authority to be looking into these murders or the underlying circumstances or the surrounding characters or anything like that, then when the head of the ISP asked them to leave, they wouldn't have had to. It's almost like the fact that they went ahead and complied with that and stepped back from the investigation suggests to me that it's because they don't really have any independent authority to stick around. Yeah. Mm-hmm. So I'm interested in your guys' thoughts about, do you guys see any kind of avenue for something like this to go forward? I mean, putting the likelihood aside, but just
Attorney General, there's, like you said, I mean, there's really not enough. Like what I keep thinking with criminal justice reform, that every state's attorney needs to have a member of the defense bar that has some sort of power, input, can say when they see something wrong, you know what I mean? I don't know how that would get implemented or what it would really look like, but it's necessary to have someone watching that. If that has not been proven by Baldwin, by all of the things and such that we have seen, but like you've got some NYSL where the judge is like, if this isn't gross incompetence, what it looks like to me is intentional misconduct. I mean, something needs to, get done. And, I don't know, Lee, do you got any big Harvard ideas of what people can do when they see something?
So in this case, I think there is a distinction between the state and the federal. I don't think the federal has a right to jump into this case or to oversee the investigation. I think it's state. And if the state messes it up, then the job is of the legislature or the executive branch to oversee what's happening in law enforcement. But I don't think that there's something that the federal government ought to jump in and handle. I just don't think that's their province. They're right. It's a shame that they got kicked out because they had resources that could have been made available. But
the state attorney general, you could at least complain maybe to the state attorney general to look into. I've been suggesting folks contact the legislature. I mean, if you want to do something, put pressure on the legislature. They have oversight authority over these agencies. And so if these agencies aren't functioning the way that they're supposed to, then that calls for a legislative fix. Yeah. It's a shame because I was like, someone needs, like the Judiciary Committee needs to look at it was just like those rulings on outside the scope, hearsay. Like, I'm like, all right, it's starting to feel like Your Honor because the series, if you're familiar with it, it's a TV series and the judges was basically being put in a type of blackmail situation because his son was involved in a crime, but whatever. He had to make rulings against, he's like, don't worry, I'll make sure he gets off, because I'm like, this is very simple stuff. Like, this is like, you don't know how to impeach. I mean, you said it yourself, Andrea. He followed impeachment to the book.
The rules for impeachment changed constantly throughout this trial. There was never a consistent rule for how you were supposed to impeach a witness. First, it was this strange requirement that Mr. McLeland put out there that you have to refresh them first. There's like this conflation of refreshing the recollection with impeaching the witness. And so that they had to do that for a while, and that got real muddy, and then they would start to refresh, and now that's improper. And then, there was the one occasion where the double standard was just so obvious to me. It was blinding, because it was literally within about 90 seconds that Mr. McLeland had objected to them not reading the question to the witness, and then objected to them reading the question, the transcript to the witness, and both of those objections were sustained. And so there was just clearly no avenue for the defense to be able to confront the witness with the prior inconsistent statement. Very, very frustrating situation for them to be in.
And it's not 100% outside of what we see in courtrooms with defense versus prosecution altogether. Like I had a case once where I can't remember exactly what it was, but then the state made an objection, the exact same thing I had just not long ago objected about them doing. And the judge is like, response. And I was like, well, whatever you just did when I made this, like, that's how it wasn't an appropriate response, but it was a level of frustration, but for it to be so many things like that, like what you just gave, and things being outside the scope, and bias being outside the scope, and things being hearsay when they're clearly not being offered for the truth of the matter asserted, like the audio from the cameras. Now, if there was audio, for example, that doctor, the one they played where he's there like that the whole time.
Yeah.
He didn't say any words. So clearly we're not trying to get in whatever is being said by the nurse, by the people, by the inmates as for the truth of the matter asserted. It goes to his mental state. It goes to the circumstances. All of those things. It's just, there were too many things that were sort of black letter law, but so many of them where I'm thinking, she runs a courtroom every day. This is, there's no way she makes these very same rulings all the time. And if she does, it's a free for all over there. And there needs to be oversight. There needs to be someone coming in and saying, what is going on? And you'd think that would have happened from the Supreme Court stuff, because that was, go ahead, that was black and white.
Yeah, I mean, it's just from a practical standpoint, we know that doesn't happen. Like, even though there might be mechanisms on the books, like, do you guys, I mean, really, do you guys think that that's ever going to happen? That a judicial review committee or a Supreme Court or anything like that is gonna slap Judge Gohl on the wrist for her handling of this case?
They had an opportunity.
And they chose not to. And they said, we're keeping the lawyers, we're keeping the judge, everybody go try the case. And then they said it again. No, we're serious. We're keeping the judge. We're not kidding. I want to say too, a lot of people say, Lee, you're a defense lawyer, and so you're biased. I'm not a defense lawyer. I am not. And I am telling you, as not a defense lawyer, that the system is not set up to be fair to the prosecution and to the defense. That judges do tend to be biased in favor of the prosecution, whether it's because they're in front of them all the time or whatever reason, I don't know. But they do tend to be that way. Juries come in and they do not believe the defendant is innocent until proven guilty. They believe the defendant is sitting there because law enforcement has concluded they're guilty. And there is a disparity in resources. And if we ignore that, if we just dismiss everyone who says that as a defense lawyer, then we're missing a very real problem in the system. I am not a defense lawyer, and I'm saying that all of these structural differences exist, and they create problems and make it difficult for defendants to get a fair trial. And they exacerbate the difference in the way a wealthy defendant is treated and the way a poor defendant is treated, because it means that the wealthy defendant will have access to things like experts who can explain things to the lawyers or can present testimony to the jury, who can actually go ahead and test that bullet and write the report that the jury is requesting, because they have a good amount of money, whereas a defendant with fewer resources cannot do that.
Yeah, this is one of the kind of systemic issues with defense that I've talked about a little bit on my channel, because it is part of a sort of growing ethic of reform that's going on right now around the country with public defense and the delivery of public defense services, and trying to make it a little bit more robust. I don't think that has really made it to Indiana yet from what I've seen. But one of the big criticisms that has been levied against systems like they have here in Carroll County, is when the judge is the one who oversees the defense funding. And part of that is because it seems to create a little bit of a conflict of interest situation. One, in terms of kind of requiring the defense to have to justify the basis for the request in light of what it is they're trying to accomplish and the role that has in the case. And so some jurisdictions will kind of get around that by, you'll have a special referee judge who's not the actual trial judge on the case, who's overseeing those types of decisions. It's not clear to me that that's what we have going on in this particular case. The other side of it too is that it's often just a general budget pool that courts have to administer for their criminal justice system. They kind of decide for themselves how much they're going to allocate to providing expert services. And so if you get to a point where you have a trial like this that is expensive and it's got significant needs for it to be a fair process, but you're now pitting the defendant's right to be able to go and get an expert against the court's interest in, updating its technology or its security or something like that. You have a whole different kind of opportunity for conflicts like that to come about. So
Absolutely.
just a big concern that I have about how that's been handled in this case.
I want to make one other point, which is I do recognize and understand that there is a problem with resources and scarcity of them. And so I know from the reporting done by one of the local newspapers, one of the local stations, that the cost of this trial has been something like $4 million to the local community. That's almost unsustainable in a smaller community that is not excessively wealthy. That's really difficult. The prospect of trying this again just has to be horrifying to them, because where are they going to get all the money for that? So I am not ignoring the fact that there is a problem with getting the resources for both the defense and the prosecution to make their case. But but I also do feel like there is a disparity that needs to be addressed, that people need to realize exists.
I mean,
Yeah.
absolutely. Did you guys already talk about any of the surprises as to what you didn't see at closing, or is that not something you're doing? Or
No, that's a good question. Good question.
Yeah.
so
Lee,
Beverly-
anything that you were surprised by that you didn't see in closing?
I really thought he needed to get into the timeline. Really thought he needed to do that. He could have done some pretty effective stuff with the fact that it was a grand total of 19 minutes from the time Libby films the abduction to the time that Abby is, according to the state's theory, lying on top of Libby's phone, which never moves again. And that is crazy. I mean, that's really fast. The steps also didn't work. He talked about the steps being enough to get down to the road right below, but I think it needed to go a step further. That might be true for the defense theory, but it's also true that the steps don't match, that there were only 2 flights of stairs. And it was, if you take the change in altitude, it's 65 feet down to the creek, across the creek, and then another at least couple of floors going up. So it should have been 8 floors. And I did think, I thought he missed an opportunity to talk to the jury about that particular issue. I felt that the prosecution mostly hit its points.
On the
Did they
timeline
put
too,
that
I think one of the things that got missed was they had such a gotcha moment there with the headphones and this new piece of information that seems to be very inconsistent with the state's theory. Headphones plugged into the phone at 5:45 p.m. and then unplugged at 10:32 p.m. Not at all consistent with the state's theory of Richard Allen's involvement. But the state was able to muddy that up a little bit with this idea of, well, maybe it was dirt, maybe it was water. That's where I think they had an opportunity, like you're saying, to tie that back into the timeline and just remind people that for the state's theory to work, that phone would have had to have, been exposed to the water or the dirt no later than 2:32 in the afternoon. And so what really is the explanation for why that phone would be functioning apparently pretty well up until the 5:45? What would have happened at that point to suddenly cause something to register? It just missed, I think, an opportunity to strengthen that particular piece of evidence and undermine that challenge that the state had tried to raise against it by making it seem more implausible that the state's explanation could fit.
So then my question actually goes to both of you, since I wasn't there, because now my thought is, for Andrea, what you just said, is it true that they were establishing that there were enough steps to have made it across the creek? And if so, if the damage to the phone was from it getting wet, then how in the hell is it tracking them all the way across the creek? And then it carries over to you, Lee, with, did they point out how many flights or steps it would have taken to just get to that access road and then a car to tie together that shortage that you just talked about?
They didn't. They left that out. Nobody really talked about that. In closing, Rosie said, well, it was 30 feet down to the road, so that's roughly 20, which didn't fully make sense, but it's 10 feet per floor. So it's like, that's roughly nobody talked about it. Absolutely nobody said, well, here's how many steps it is. And that seemed like even sort of an easy thing the defense could have done very, very cheaply. Okay, we walked this many steps, how much, just literally take your phone out there and see what happens and measure it.
And Andrea,
even just some basic measurements, because we really didn't get any of that. We don't know how far it would have taken to get from where the girls were on the bridge to down the hill to across the creek to, the location where they ended up. Even just a basic measurement of that to know whether that corresponds with the data, I think would have been extremely helpful. Now, of course, we didn't get to see all the exhibits that the jury did because we peons weren't allowed to enter the bar, as you know very well, Allie. And so we know that there were some maps entered, some topo maps and things like that. But I never did hear any type of testimony about measurements or anything like that that would have tied that together and either allowed us to say, yes, this corresponds with the steps. We heard testimony that the steps are probably the most accurate part of the health data. And so that was a potential opportunity to either validate or invalidate the theory of what those steps are representing. It just never got answered.
But did they show, or did they allege, or was the steps indicating that they went down the 2 flights, whatever, got down the hill, and then took a very numerous amount of steps that could have been across the creek? Because then I don't understand. Did the phone never get wet? Because why would it be tracking the steps?
So the way that it came out, and you can correct me if I'm wrong, Lee, but what I remember from this testimony was that the elevation change that the Apple Health data recorded was not set at a specific time. It was just reflected within a larger period of health data that was being recorded, where there was a variety of activities. There was steps that occurred, there was distance moved, and somewhere within that time frame there was an elevation change. So it just never got pinned down to where in that particular section. And it was fairly long, if I remember right. I mean, it was like a 9-8 maybe 10-minute segment of time. They just never were able to pin down, okay, well, where did the elevation change happen within the course of that entire process?
And they gave a range of time from 208 to 225, and Libby's phone moved 414 meters in that. That's a problem right there. Everybody's like, meters? What are meters? How far is that? And
but that is a very important point.
It is.
Defense could have cleared up with, I'm assuming their FBI agent, probably she knows how to convert meters to feet and could have painted that picture for the jury. But I'm one of those people. Like when I'm in London, I was like, I kept saying, wait, so is it meters? How far is this? You need a visual. So is it fair to say we're not sure if what they were either arguing, the prosecution, or what they presented made it seem like there were steps that took the girls across the creek?
Well, they didn't really ever specify. They then told us there were 68 steps from 225 to 231. See, that's a place where the defense could really have some opportunity, because that's the last few minutes before the phone is going to be in that area in the forest. That's a 6-minute period of time. That is exactly when they're going up the hill on the other side. And that's not very many steps. And they're crossing the creek. They're doing all of that. They've only now seen the van. So, and all of that has to happen really fast. And 68 steps, that is not very many. And I just felt like there was a whole lot of opportunity there to say this was impossible. Richard Allen literally could not have done this. Look at the phone data.
I'll tell you, after I heard, very good. After I heard Bob's closing, what I text was, I'm effing floored. I am shocked. I didn't hear one word about the bodies, about the clean hands, about the direction of the blood. That, I mean, I was like, they could have at least said to the jury after they put that picture in, look, here's this picture of the Weber's garage, and it's got this, what the hell is he doing with this branch? There were branches at the crime scene right there. He could have said, look, I understand it's hard. I could have done it because it's actually true that looking at crime scene photos, especially ones with children in it, is very difficult. But you're going to have to look, and you're going to have to decide, look at the branches, look at the positions. This is something that took someone time. It was something that was meaningful to them, the way this scene was left. You look at it, you decide, but you got to do that. I know it's going to be hard for you, but you got to look at it. You got to look at the branches. You got to look at and you decide, does that fit in this 7-minute, whatever minute thing that, or that somebody who was scared and rushed, then you spend another, hour and a half. To me, that was, even if you didn't want to get into all of those things about, the way the blood's good, like at least tell them you guys are going to need to, because do they have to ask to see those crime scene photos, or are they back there? Because jury hasn't asked to see anything.
They have copies. They have copies of the photos.
I just feel like pictures like that, they're going to want to avoid. Like on the, a child murder case, I took the entire, I refused to look at the pictures, and they're like, you're gonna have to be able to look at the pictures at trial. And then when I finally looked, I was like, that looks, because one of the arguments was these two murder victims, their injuries, their knife wounds were similar. Like, there is literally nothing similar about this, nothing similar. So I feel like they're not going to, unless they got, and you guys were there, so you have to tell me, unless throughout the trial, they did get enough of a sense that there's something off with the scene, something off with the way the bodies were positioned, or all of those things, that they're not going to think, well, we don't need to see the crime pictures. We know the girls were stabbed. They were left, you know what I mean? Like, they might not even look at the pictures again.
Yeah. No, I think that you're right. I think that was a big, it was a big issue to kind of leave on the table there, because it was a gift from Dr. Kaur. He really, none of them really, including the crime scene investigator, nobody could really explain Abby very well, at least not to my satisfaction. The doctor indicating he's never in his entire career, after thousands of autopsies performed, he's never seen a situation with an injury like this where the individual would not have had some type of blood on their hands. The instinct is simply to cover that wound. That's a really important piece of this case. Even just the kind of dubiousness of this explanation from my perspective, that the sticks are placed for covering purposes, like for concealment. This is just nonsense. I mean, these are tiny twigs, some of them. There's nothing concealing about them whatsoever. If you want to cover them up, you have tons of leaves there to be able to do it, and it's probably going to be faster and more effective to do it that way. But the peculiarities of the crime scene, they really didn't get to develop, and I think part of that is just because of the limitations they had with the third party culprit. And I thought that was a particularly inappropriate limitation once the state is allowed to go in and offer its explanation for its theory for why the crime scene looks this way. Their theory that Libby was moved for purposes of making it harder to see her from the river. That the blood patterns explain this certain type of activity and so forth. They were able to go. The marks on the tree were just a transfer blood stain, probably from Libby. And so once they were able to explore all these opportunities, it seems to me extremely unfair that the defense doesn't have the opportunity to point out, actually, we think this stuff has symbolic meaning, and we have experts that would attest to that. What do you think about that, Lee?
Yeah, I agree with you. I do agree. I think that one of the issues with ruling out all of the third-party evidence and all of the Odinism is that it created some downstream effects. It wasn't just that they ended up not being able to talk about third parties. They ended up not being able to talk about some of the things, just like you mentioned, with the sticks, with the staging of the bodies, with the appearance of the bodies, that would have been helpful to them. I think it would have helped too if they had had a blood spatter expert. I think they could have hit those points again. They managed to get out of the expert, that it was odd that the blood went this direction. It was odd that there wasn't enough blood under Abby. It seemed less than expected. So they got some facts out, but they needed to hit it again and explain it to the jury. And again, I'd be willing to bet it was just a matter of funding. And that was one more expert, and they had so many to hire, they weren't able to do all of them.
Yeah. Yeah. Here's a question. I think this is a great question. I'd love your guys' take on this. Which witnesses do y'all feel jurors found most compelling and genuine? Were there any they seemed uninterested in? Thank you, ladies.
You were there.
What do you think about that, Lee?
Well, the one who comes to mind, and it's not compelling and genuine, it would be the opposite, would be Sarah Carbob. Really, they went after her on the defense cross. Rosie talked about the fact that he sort of made fun of her and made several comments. I honestly didn't think that seemed to hit with the jury.
I didn't either.
He did it 3 or 4 times, at least 3. And, sort of like, oh, yeah, well, I'm not even going to talk about her kind of thing. And you can just dismiss her testimony entirely. And I think they thought, well, why? Why would we dismiss her testimony entirely? There is video of her car passing the Hoosier Harvest store. So she isn't completely making this up. And from the beginning, she said she saw somebody, be it muddy, bloody, whatever. She saw somebody. So I just felt like that didn't really fully hit with the jury. So I'm glad you thought the same thing. So
I found it counterintuitive, at least in the closing. I'm like, she's your best. She's like, she's very good for you. What the hell was he scared of that he spent an hour and a half? What did he do an hour and a half with 2 dead bodies?
And how do we line this up with the part of his confession where, the detailed confession where he's saying he avoided the trail so that he would avoid, traffic and avoid detection. But yet you go to the higher populated area where the cars are going by and you're more likely to be seen. It just didn't make a lot of sense.
Right.
It seemed to me like leaning into Sarah Carbaugh would have potentially been a better strategy.
That's I absolutely, like, as I was listening to Bob say the closing, I was like, what? And and look, it's very easy, I understand, to Monday, what do they call it? Quarterbacking Monday, whatever.
Monday morning quarterback, yeah.
Quarterback. Bob's like, oh my God, she's not trying to make a football analogy. Monday morning quarterback. And there has not been a time that I walked out of an opening or a closing or a cross-examination, where I'm not like, oh my goodness, I forgot to say this. I forgot to say that. So I don't mean to be sitting over here like I'm trying to be really, really critical or like I could have done it better. I'm not saying any of that at all. I'm just saying these were things that to me just kind of stood out. And again, I did think, I'm like, you know what? The jurors didn't need him to necessarily go over all of that at closing if they're going to look at the pictures, because sometimes it's better to let them come up with that on their own. And if they looked at those pictures again, if they really looked at it, someone reminded them at least, look at the sticks, look at the pictures, look at the sticks. The sticks, for exactly like you said, obviously they're not, like, it just screams disingenuous. Then the cops are saying he was doing it to conceal them. But they're the same. Each of them have one on each of their arms and across their bodies. Like they're set up in a very similar way. Like, and I feel like somebody could have had their own aha moment. You know what I mean? Like if they with them not necessarily spelling it all out. So I just wonder, are they going to look at it? And that's where I wanted to hear you guys again answer. Do you think enough was said during the trial that's going to make them be like, well, let's look at how these sticks were lined up. Let's look at, is there something weird about the bodies, or wasn't?
No.
Yeah, I don't think so. And I mean, going along that point as well, there's sticks on one of the pools of blood. There's sticks arranged across one of the pools of blood. This had to have happened after the blood was spilled on the ground. So this is a deliberate placement. Are we trying to conceal? Are we trying to conceal that? It's not a consistent and cohesive theory, but I just don't feel like the defense necessarily had the opportunity to really point that out, or just didn't take advantage of the opportunity, like the limited opportunity they did have, to just point out, like, look, guys, this looks weird. Right. Look, this looks weird. Is this doesn't seem to be explained by the circumstances that the state has suggested that this is just a crime of opportunity. But there's all these things that we really can't account for. And I mean, I'm with you, Allie. Yes, we are Monday morning quarterbacking to some extent, but that's because we're analysts. I mean, that is really what our job is to look at the performance and critique it. We've certainly done plenty of that with the prosecution and with the prosecution's case. It's fair game to look at the defense's performance as well. It's part of what we're here to do.
So, I wanted to throw out one more thought on Summertime's question, which was about the witnesses that were most compelling and genuine. The most important witness in the entire case was Richard Allen himself. Granted, he didn't take the stand. I'm not talking about witness who took the stand, but he testified in the form of the audio recordings we heard of his confessions to his mother and to his wife. You could also argue he testified to some degree in what the guards wrote down and what Dr. Walla wrote down, but we heard his voice. We heard him talk in those conversations, and that is of utmost importance. What they believe about whether he was compelling and genuine is going to be incredibly important to how they decide the case.
I think that's a really important point. And if we're looking at Richard Allen as a witness as well, the fact that they were also able to get those interrogation videos in was such a key victory for the defense, because if all the jury had to evaluate Richard Allen and who he is and what he sounds like, is that information that only came out after he was in prison and he's under the stress of all that, that's potentially a really bad situation for them, because it just looks bad. And one of the concerns I'd always had is the tendency that Richard Allen, lost his mind in prison. Richard Allen is acting psychotic in prison. This has the potential to feed into a, pre-existing conception of this crime that, frankly, I think is pretty fair, that it would take a real psychopath, to do something like this. Right. And now here we just have Richard Allen looking like some kind of psychopath. So the fact that they had that pre-arrest, pre-incarceration baseline to be able to go back and refer to and not just have the accounting of what was said in the interrogation presented by Holman and Mr. Mullen, that I thought was an absolute key victory for the defense. It was a big misstep by those witnesses to testify so much about Richard Allen's demeanor and changes in his demeanor to suggest that his confessions were grounds for them to be, or his interrogation was grounds for them to be suspicious of him, because that's what opened the door to it. And ultimately, then when we did get to see it and we get to evaluate his demeanor, I don't know about you. I want to know what you think, Lee. I thought he came across as extremely credible, perfectly normal, exactly like anybody who is being accused of something they didn't do would behave under those circumstances.
I definitely agreed. The interviews were a really important contrast to what happened later in the afternoon. They did the 2 interviews, got played in their entirety, and then they moved into the guards, and it was so different because the guards were describing a situation and a person who sounded like a radically different human being than the one we all watched in those interviews, who did seem very reasonable and absolutely certain that he had not committed this. Over and over, I did not do this. I cannot tell you, I am not going to admit to something I didn't do. I didn't do this. And it really did seem like the way you would probably react.
So did they mention in closing that you heard the state, all this, I get their theory, like ask yourself why the state didn't show you this or why the state did that. Was there anything along the lines of ask yourself, why did the state call all of those guards to come in here and tell you they, in their guard skilledness, say that he was feigning, but the psychiatrist answered your questions, jurors, your question, and said, I saw no evidence of feigning. Was that incorporated in the closing?
No, they really didn't. They really didn't address that part, and that's actually part of this question that I would address too. The most compelling witness I thought really was Dr. Westcott. I mean, closely followed up by Dr. Gracian, but Dr. Westcott in particular, because she had such a comprehensive overview of everything in the evaluation that she did relative to any other witness in the state. All of the Dr. Walla, Dr. Martin, obviously the guards, they all just had a very limited perspective because they weren't looking at the videos. They weren't looking at, all the other pieces of the puzzle, the communications with the family on the phone, the total medical history, all of that stuff that she was able to rely on and incorporate into a much more comprehensive picture. Obviously, before you even get to she did actual objective testing, which is should be an absolute baseline, in my opinion, to be able to testify in court that somebody is faking a mental illness. There's literal instruments to be able to evaluate that any competent forensic person is going to rely on before they make that type of claim. But that was, I thought, really important because her view was just so much more comprehensive that I thought it made it a lot more persuasive. It was just very effective, I thought, at being able to counter those claims that were being put out by Dr. Walla, by the guards, that this was just manipulative behavior. This was attention-seeking behavior. So just a real critical piece of the puzzle. And I found her a very compelling witness, very credible, very professional, and that kind of stood in contrast to what we saw from the clinicians who were treating him.
I did think a couple of the prosecution witnesses were very effective with the jury. Oberg was one. She was a ballistics witness. I thought she was really effective. And the jury really seemed to and ask a whole lot of questions, explain to us, to the second psychologist. Do you recall her name, Andrea? For the state, the second one, not Walla, but
Dr. Wenger, the one who was the administrator for Department of Corrections, the non-Centurion psychologist.
They treated her like a tiebreaker, kind of okay, we weren't really sure what to believe about Wallace, so you tell us about, and then they asked a lot of questions.
Yeah. Here's this is not necessarily a question, but it's a comment that I'm definitely interested in your takes on, because this was definitely something that we called out kind of when it was happening at trial, because I thought this was a major misstep by Jennifer Auger. that she kind of opened the door to this particular piece of information being brought out. And it was during, I believe it was when Cecil, First Sergeant Cecil was on the stand, and she's cross-examining him. She's wrapping up her cross-examination. She goes and stands next to Mr. Allen, and she says, you searched all of his devices as well, and all of that. You didn't find one single connection to him, to the crime scene, to anything like that. No, he didn't. It seemed like a really strong moment in her cross-examination. But then as soon as Mr. McLeland gets up, he's addressing, you seized over, 18 devices or something like that. And was that 2017 phone included in those devices? It was not. And I'm like, ooh, that's bad. If they don't have a way to come back and rehabilitate that with, this is not a complete collection of all of his devices ever. Like there's other ones that are missing, or we can account for, why this particular one is not there. This one got traded in here, like something like that, to try to make this explanation that does look really bad. If the state has seized all of these devices and that's the only one that's not there, that's a bad fact you have to deal with. And I don't necessarily think that they did.
They did
Does say
not.
how many other of the devices were phones specifically, and what years or types?
We didn't get a breakdown of it, but we saw the photograph of what was seized, and yeah, it was lots of phones. It was like at least 12 phones. It was a lot of phones.
I mean, I just think, I don't know why, and I don't know, maybe you guys know the answer to this, because if he had, I don't know if he had an iPhone, but if he had an iPhone, your iCloud stores all of that data regardless of the device. Same thing, I'm assuming, with an Android in a very similar way. I've had cases where they don't have the device and they download a backup from the iCloud.
Mm-hmm.
They get a warrant for the iCloud. So it's not like getting rid of the device put an end to getting at his data. But I'm assuming, since the defense didn't point out, well, there was only one other phone and it was a flip phone, or there wasn't many other phones, that there must have been I'm assuming there must have been other phones there.
Yeah. And so we also knew Rick was an Android user. He was on an Android phone. And so we never heard really anything about Google and how, Google services compare to the iPhone. We heard a lot about what they're able to get from iPhone and the iMessages and all that stuff. But really didn't hear about that with respect to Android. Now, we do know that they were able to get those Google searches that they brought into evidence, that some of which went all the way back to 2017. So we don't really know the source of that. But it does suggest, maybe that was through a Google account, similar to the way that the iCloud type of account functions. We also didn't really get anything about sort of the level of extraction, like the type of information that is available through the extraction on the Android compared to on the iPhone, because you can get certainly a lot of the user data from a backup like that, or even just because it will, when you get a new phone, you'll just update your phone and incorporate your old data into your new phone. So all your preferences and contacts and things like that will carry forward. But we didn't hear about things like, for example, the Apple has the Knowledge C database and all that information about the usage of the phone, all the different apps that store the location data in the phone. And so that's the type of thing. It's not clear to me they would have been able to get any of that without going to the phone itself. So just left some open questions there that, I thought that was very unfortunate.
That got in through one witness that, yes, this data would still have been available, but it was just a single question. It wasn't really discussed, just as Andrea said. And wouldn't steps have been really, really useful? Did Apple have that in 2017? I don't know, but boy, it would have been really good information. Even if we had learned they didn't have that, it wouldn't have been available. Well, it had to have been, because Libby's phone had that. So as long as he had a reasonably updated phone, then it would have had the steps data. What if it didn't?
Well, I'm
match
not sure
Google?
that the Android's phones have that.
Did he have an Android or an Apple?
Yes. Yeah, he had
An
Android.
Android.
He had
Okay. In
Android phones.
2017. Okay.
Yeah. Yeah.
I think you guys both have. No, you have an Android, don't you, Andrea? Your
I
texts
do.
are
Yeah.
green.
Yeah.
So is there something like the iCloud where it stores your data, so when you get a new phone, you can download it and it'll go back?
Yeah, it backs up to Google. It just backs up to Google. You have it, it runs through your Google account. And I have no idea, like, comprehensively, how does it compare to what you're able to get from an iPhone? You know, how those things, if you put them side to side, like, does one of them store more? I really don't know. So
Now that I
it's
think about
kind
it,
of hard to
all
gauge
the
that.
extraction reports that I've looked at have been for iPhones. Like
Yeah.
I actually can't remember seeing, an extraction report, but they can go back at least on the iPhone data, even from the iCloud, and see
Mhm.
what apps you had open at what time. I mean, we've seen it all in between Read and now I'm blanking on the other one, but that they can tell when you have an app open and when when it opens and when it closes, and if it's stagnant. He
Mhm.
was. It's a shame because, in my opinion, first of all, in my opinion, without a doubt, hands down, as a lawyer and a human being, this has not been proved beyond a reasonable doubt. I have no hesitation saying those words. And I try to be, my family is asking me, like, while I'm here, and I say, look, I'm trying with myself to say, be as honest with yourself as possible. Do I think he did it? Like, that the evidence shows he did it. And I honestly don't think it does.
I don't either.
I just don't.
I want to bring Bob back on. We've got him backstage. He got back from his obligation. I'll just go ahead and make sure folks know we are going to probably try to wrap it up pretty quick here. Lee has done us all the favor of requesting that we put a little bit of a cap on this, because, as you know, if you watch my channel, I am not very disciplined when it comes to cutting off the stream.
Either am I.
This has been such a good conversation, and there's so much stuff to talk about. I want to, if you guys are okay with it, I would love us to address this question as kind of our last one, maybe before we try and wrap up, because this was something that we've talked about between ourselves, because it's something that we have different thoughts about. The jury questions being a part of that, and also the ability to evaluate, to talk about the evidence before they go into deliberations. It's these kind of unique rules that Indiana has for jury participation in the trial process, and so. Not sure I like jury being able to ask questions as you go, allowing jurors to become slanted to state's witnesses first based on their answers, then the delay in their mind before the defense's whole case, example, i.e. ballistics. Very interested in your guys' takes on this. So, like, Lee, do you have jury questions where you practice, and what are your thoughts about this?
We do not. I had never had that happen in a case before. It's interesting to watch because it's kind of like watching jury questions that come out during deliberations, and they give you all kinds of clues about what is happening. Lawyers dissect those, spend hours going over those. And this was an early chance to sort of see where the jury was leaning. I do think it does do exactly what Debbie is talking about in her question. It does allow people to become kind of cemented and to congeal their thoughts around a certain viewpoint, because once they ask that question in front of their other jurors, they've kind of taken a position on that. I also thought some of them were kind of using them to talk to one another. And so it kind of gave you the thought that they probably had their backstage conversations, which are even more problematic in my mind. And those backstage conversations were leading them to say, well, see, I told you such and such, which is even more of a sign that they were sort of gearing down into particular positions. I did think, though, their questions were excellent for the most part. They were really helpful. They really they were often things like, oh, Yeah, that's a really good idea. Why didn't no one ask that? Let's find that one out. And
I remember when they asked the question about the DNA reagents, and my jaw just about dropped. Like some of these questions, they belied a very technical and sophisticated understanding of some very technical and sophisticated issues. And so that was a real tell about the kind of background information that the jury was going to have back there in the deliberation room that could potentially play a role in how they're evaluating this whole process. In Washington, we are allowed to have jury questions, but they are considered disfavored. It's within the discretion of the judge to allow it or not. So I have only had one trial where jury questions were allowed. I found it a rather awkward process. Because like we were talking about earlier with that one question that it had been objected to, the judge sustained it and the jury asked the questions. And now this time the judge is going to allow it to go forward. Most of the time that I would find the jury was asking stuff that's just not admissible. I mean, I understand why they want it, but there's not a valid way to be able to get that information in. It was objectionable. And so I would imagine it would be very frustrating from the jury from that standpoint to, be told like, oh, you get the opportunity to elicit more information. But no, actually you're not. Like, just go ahead and shut up and sit down and listen to what we have to tell you. It almost seemed like to me, that example was a good example of it maybe veering a little bit further over to the further, further extreme of how the jury questions can go wrong. They're asking things that are well beyond the scope of the examination. They're asking things that yes, objections have been sustained to that topic. And so I kind of like the idea in principle, but it's just in practice, I'm just not sure that it works.
Yeah, I'm of the mindset, and Lee, it's almost as if Debbie Richards is in your brain, because like that is exactly what Lee said when we were talking about the subject earlier today, like almost identical. And it is a bit of a double-edged sword. I like the limited concept of being able to kind of dive into the minds of the jurors throughout the course of the trial. We don't get to do them in Illinois. They're not a thing there. We don't get to depose witnesses prior to trial either. We're going in blind every trial in terms of any kind of state witness. If our PI hasn't been able to make contact, we don't get to talk to them. So, we're basically going off if they've made a statement, whether it be written or a police report, and that's all we have. So with the jurors, though, I think Lee makes an excellent point. I think that you do worry about that concept of the fact that, okay, you're hearing the state's case first, you're hearing their witnesses first. These are obviously going to be things, at least if the state's case is going the way that they planned it to go, are going to be things that are not positive for the defendant. And are those things kind of sticking in their mind to the extent where they're like going back, especially when you put in the fact that these jurors are allowed to discuss the evidence during the trial while they're sitting on a break, which blows my mind. Allison was like, what? Well, so when you couple that aspect with the fact that they're able to ask the questions, and it might be cementing things that, as the defense attorneys handling the case, you don't want being cemented in, it creates a real dangerous gambit, I think. So I think where I initially really liked the concept, Lee really opened my mind to the fact maybe I don't like the concept so much. So,
and I was going to say that Bob literally took exactly what I was going to say, because my answer was going to be, I actually think it's great. It gives, although it can hurt either side, right? Because like then the prosecution went and they did some work to answer the questions, but the defense gets that same opportunity to see their mindset. But again, Lee's response completely changed my opinion on that. Like, Lee opened my eyes, because I wrote down, Lee's right. They're using the questions to prove their points. And once you make a point, you're right. You're now like, I knew it, So yeah, actually do. But from a strictly, like, my mind wasn't even really going there. And even with the question, my answer was still going to be, no, I actually think that it's good because wow, I'm getting a window. I know what's important to them. I know what they missed. I know what they didn't miss. And again, even though kind of both sides do it, but yeah, Lee's answer made me reevaluate.
Yeah, it had a big influence on me too. Just looking at it through that lens, like particularly with the evidence and being able to review the evidence during the breaks and stuff. This initially struck me as very strange. As time went on, I started to think it over, and I started to think, okay, well, maybe I can see a little bit of upside to this, because one of the problems you have, especially with a trial this long, is by the time you get to those deliberations, so much of what's happened early on, it's no longer fresh. And so you're having to go back and kind of incorporate stuff into your thinking that has been just overcome by the volume of everything else that you've had to think about in the meantime. So I could see that as being a little bit advantageous, that you get to process some of that while it is still fresh. But that is exactly the kind of counterpoint to that, is that by processing it, yeah, you're starting to make decisions about it, and you're starting to get potentially entrenched in those viewpoints about it. And like you said, that the questions, this was a constant theme on my channel as we were going through some of these questions, because so many of them, they appeared rhetorical. They didn't even really seem like they were asking for an answer. The series of questions about, how many vans, is his the only van that's on Brad Weber's driveway? Is his the only van that's on 625? Like, this doesn't seem like a question that is really asking for a straight answer. This is a question that is making a point about, you're trying to draw an inference here that's maybe beyond the scope of what you investigated. So I think that is such an excellent insight, and it's one of the things I love about this panel and these different minds, and the chance I've had to meet all of you and talk to all of you and get your thoughts about this, because it's just such an excellent insight that, yeah, by having that conversation, you're cementing, and that's not necessarily beneficial to the deliberation process.
Yeah, and I've always been of the mindset that you can't unring a bell, right? I mean, it's that old adage that I think holds true. And, even with forming an opinion prior to trial, which I'm always on my channel screaming and yelling, look, we're all human. We're all going to form an initial opinion, throughout the course of us, like, consuming true crime, if we're not in the courtroom, but as a viewer or an observer, we're typically used to hearing the state's theory of the case. So oftentimes people that are outside of the realm of the trial itself, but are observers, but our potential jurors, are typically forming opinions, which I don't know that they can ever truly step away from that opinion that they have formed. I understand, and all of us are trial lawyers. All of us have gone in there. We've all heard the judges say, I'm going to rehabilitate you because I understand you formed an opinion, but I'm going to ask you flat out, can you follow the law? Will you listen to the facts, and can you follow the law? In those two simple questions, if that juror says yes, the judge considers them rehabilitated. And as a defense attorney, I'm mortified. I'm like, what? There's no way in hell they're not going to, like, what are we doing, crazy world? So
talk about a rhetorical question, right?
Yeah.
Exactly.
Yeah. Well, guys, we have kind of reached the end of our deadline that we put on ourselves, because
Andrea, before you guys go, would you mind? I would love to do it at the end of this, because I don't know we'll have an opportunity once it gets to verdict. And I think you guys were out there at the bridge at the memorial. There was a letter that I've taken a picture of. I've read it a couple times. Can we close with reading that letter to Abby and Libby?
Sure. Yeah, I think that would be great. So I was just gonna just kind of wrap us up by pointing out, we still have trial to go. We got to be back there tomorrow morning again for more verdict watch. Lee and I are both sticking very close to the courthouse because we don't really know how much notice we're going to get or what kind of process it may take to get in the door. Things have gotten a little bit more feral in the crowd over the last week or so, and so we just want to be prepared to not be able to lose that opportunity. We are both working on our sleep debts, and so it was going to be important to make tonight a little earlier than I'm used to, so that we can try to get caught up on that. But I've really enjoyed this, you guys. I think this has been fantastic. There's obviously a lot of questions that we weren't able to get to, and I'm sorry for that. But I would certainly be willing to do this again if we have more time where we're just waiting and there's nothing really new happening in the trial process. But I would just put that out there. No pressure, of course, 100%. But
I think missed a big chunk. So like I was, all things being honest, I would have rather been here with you guys than doing that court TV thing. So like beforehand, I'm like, Andrea, let's move it up closer. She's like, Jeff can't do it. So I knew, but I also wanted your viewers to be able to meet my brilliant wife anyway. So that worked out very well. And I'm sure that everyone enjoyed having three amazing female attorneys, just blowing minds with their brilliance. So I'm excited about that, but I'd certainly love to be able to do it again as well. If the jury's still deliberating, why not?
Yeah.
What else do we have to do?
Well, I don't know if I can share this thing, so maybe I'll just have to read it. I tried to share my screen.
I can pull it up right here.
So, and this is right outside their memorial. And it says, "Dear Abby and Libby, you never met me. You never interacted with me. You never heard of me, but you've guided me. The circumstances of me hearing about you girls weren't what they should have been. However, the legacy and joy you both brought to this world is something I will always aspire to bring in y'all's honor. Love, devotion, wit, brains, and happiness is what the world needs right now. So I may not be able to give you both the true justice you guys deserve. I can use your virtues of love, creativity, kindness, athleticism, baking cookies for life for Abby, and crafting for life for Libby, and crafting for life for Abby. Love, live, and light up the world like the girls did. And this world will have incredible times ahead. May both of your beautiful souls rest in peace with much love and vengeance for justice. Sam."
Well said.
I got the chills. And I've read it before, and I still get the chills. I just thought that would be a nice way to end.
An apropos way to end. Sure.
Yeah.
Sure. Thanks, Allie.
Yeah, thank you. Well, thank you everybody for joining us. I hope you've enjoyed this as much as I have. It's been a fantastic stream. And yeah, we should, if we can, we should try to see if we can make this happen again in the future. So I really enjoyed the chance to get to meet all of you, and looking forward to seeing you guys again out on the street tomorrow.
And if on the just unbelievable odds that you haven't subbed to both Andrea's channel and Lawyer Lee, absolutely go and do that. You see what you're going to get right here. So make sure that you guys, if you're our viewers or our subs, make sure you guys are subbing to these guys because they're amazing. You just evidenced it right there. So you guys are wonderful. I'm so happy that I've been able to do this with the three of us in there. I think I'm not going to lie. I think it was important work, and the yeoman's work that you two have done dealing with that line situation is above and beyond. So I'm grateful to both of you. And I'm thankful that you've been here doing this with me, because I was worried that I was going to be the only one in there. And it's so important to have attorneys in there doing this, and we're playing the role really of, court reporters. We've all had to kind of really sacrifice being able to observe other parts of the trial that we would have liked to have been able to observe, because we've sacrificed by writing everything down, trying to get down every word. So our eyes are typically focused down on a pad of paper as opposed to being able to observe the witnesses. But, you know, it's for the greater good, you know, that we're doing it all.
And thank you very much for the reminder, Bob, since you mentioned the work that we are doing in the line. We are still needing help with our line sitting as we're continuing to wait for the verdict to go forward.
Bob.
We do have a line in place. We are optimistic that that will be respected and that will hold. And so we are doing our best to kind of maintain some order and civility in the process of just being able to get back into the courtroom for the verdict. But we do need help to be able to do that. So if that is something that you are in a position to be able to help us with, we would absolutely create it. Absolutely appreciate it. Lawyer Lee has a sign-up sheet. I have a sign-up sheet. I'll go ahead. If Lee, if you want to email me your link, I'll make sure that they both get into the description for this, so that if folks are in a position to help, they can access those and sign up to do that. So with that,
you
guys,
have your own little piece in all of this in a small way. So hopefully you get some extras.
We were burning the candle at both ends for the first couple of weeks before our angels from heaven stepped in and just kind of decided for us that they were going to line sit and arrange that. And I'm extremely grateful to them. I know that Lee has been as well. We could not have done this without them. It's very much been a group undertaking, and so that will always be something that's been very special about this whole experience.
Yep. And finally, Jeff Burkhart, thank you for putting this together. We appreciate you getting this stream put together for us. And to all of our mods that are out there modding, thank you guys. We know that all of you have been doing just an incredible amount of work for all of us as creators. And we are always so very appreciative of everything that you guys do for us. So, and to you guys, all of our subs, we love you guys. And we'll talk to you tomorrow.
All right.
Thanks, everybody.
Thanks, y'all.
Thanks.